Your Honor.
Yes, ma'am.
Okay, we are ready. This is Joshua Jones and Mr. Asias.
All right, this is cause number CR 25-206 and 207, State of Texas versus Joshua Caleb Jones. Mr. Casillas, I show that Mr. Jones is set for docket call today. Any announcements?
Your Honor, I've been talking with the prosecutor. He said he was going to approach you regarding trying to keep this within the rules of HIPAA and all that, regarding a fact that the state was trying to get confirmation of that would affect how one charge would be prosecuted. I don't know if he had that conversation with you.
Good afternoon, Mr. Casillas. This is Mr. Hernandez. Your Honor, I did have that conversation with Mr. Casillas. I did not want to have an ex parte communication, Judge, but just the way Mr. Casillas has addressed it, we're trying to confirm the difference of whether or not the charge may be different based on some medical information that we're seeking. Unfortunately, with the holidays and the fact that some medical folks keep saying that we've been requesting the wrong documentation, it has not been easy to confirm that. We'd asked for one more docket setting in hopes of having that, because it will make a difference as to what any disposition in the end would be under those circumstances.
So you just need a reset time, and that's the HIPAA issue is something that doesn't require court intervention. It's something you all are working on.
We are working on that with a subpoena ducis tecum, Judge. We hope it doesn't get to the point where we have to ask for a hearing, but that's certainly where we are now.
Okay. How much time do you need, Mr. Hernandez?
Judge, maybe 6 to 8 weeks.
All right. Mr. Casillas, are you available on either March 3rd or March 5th?
It'd be on March 5th, Your Honor.
Thursday? Okay. All right. Court sets Mr. Jones then for docket call March 5th in each case at 1:30.
And this is also case number 208. I didn't hear him call 208.
Oh, yes. I'm sorry. I didn't, but I meant to. Cause number CR 25-208. Correct.
Thank you, Your Honor.
You are.
He gets the yellow. So it's always at 1:30 if they're in custody. When I'm talking, he should be released.
Okay. Your Honor, we free to go?
Free to go. You
Thank
are.
you.
You are.
Oh, yes, such good. You know the day.
Right.
Who's back?
Your Honor, Mr. White is ready on Mr. Follis.
All right. This is cause number CR 25-13, State versus Michael Anthony Solis, and we're set for docket call. Any announcements, Mr. White?
Yes, Your Honor, we need to set this for a plea, and it needs to be in the afternoon.
Okay. And how much time do you need, Mr. White?
We'll take as long as you want.
Well, I don't want to. Is it going to be for a pen time plea or a probation plea?
It's pen time plea.
Pen time plea. How about 2 weeks on January 22nd?
What is that, a Tuesday or a Wednesday?
That's
Thursday.
It's a Thursday. It'd be 2 weeks from today.
All right. I can probably do that. I'll know a little bit better this coming Monday, because I have some meetings with some nurses and some things that are going to be trying to set up a schedule. But once again, what date?
The 22nd. January 22nd, 1:30.
Just let me know.
And if you're not available, just let Mr. Abraham know and we'll get it figured out.
Okay, thank you, Judge. That's really all I've got today.
All right. Thank you, Mr. White. Good to see you.
Good to see you.
You want to get some out or what do you want to do?
Yeah, we can go ahead and get some out. We need some at least reset.
Oh, I've already got them out there. Hey, just a moment, Your Honor.
Okay, court will stand in recess till you're ready.
Oh, no, we're ready. I mean, I just. We're ready, Your Honor. Well, I don't.
Like I said,
Oh, I just had to get Mr. Manning over.
who you ready on?
Judge, we can start with Mr. Ogletree.
Court calls CR 24-307, State of Texas versus Philip Andrew Ochiltree, and we are set for pretrial.
Yes, Judge. I have not had an opportunity to go over the discovery with Mr. Ogletree, and we request an additional pretrial setting so that we can discuss the facts of his case, potential defenses, as well as any negotiations that we have on this case.
No objection, Your Honor.
All right, you want to set it for February 5th?
Yes, Judge.
Court sets Mr. Ochiltree then for pretrial February 5th at 1:30.
Sign that and
Who's next?
next, Judge, ready on Mr. Nicholas Deal.
Nicholas Ryan Deal, CR 25-227, CR 25-228, CR 25-229, CR 25. Yeah, 229. Mr. Deal is set for docket call in each case. Go ahead.
Yes, Judge. Mr. Deal was just provided a plea offer in his case yesterday. I was just because Mr. Deal is in Henderson County, I was unable to get communications with him until today. And so we would request the opportunity for him to consider the plea offer. Judge, I believe up to this point, we've been heading to a jury trial. And so if the court would like for it to set it for jury selection, we can do so, just provided that if he does choose to accept the offer that was made, the court would allow that to remain open, that option.
How about we reset for 2 weeks and it'll give him time to review the offer and you and he can discuss it and we set it for January 22nd.
Yes, Judge.
All right. Court sets Mr. Deal for docket call January 22nd, 1:30.
Thank you, Judge.
Thank you, Judge.
You're welcome. Would you like next?
Judge, next we got Mr. DeMarcus Hyder.
All right, this is cause number CR 25-205, State of Texas versus DeMarcus Leon Hyder, and we are set for docket call. Go ahead.
Judge, since our previous pretrial setting, the state's provided me some additional discovery based on our negotiations at that point in time. In speaking to my client, he would request for an additional docket call so we can discuss the impact of the new information on his evaluation of the case.
No objection, Your Honor.
How much time do you want, Mr. Manning?
Judge, if we want to keep it to the 22nd, I'm sorry, the February 8th, that should work.
February 5th?
Did we get it February?
Yeah, February
Yes,
5th,
Judge.
Thursday.
Yes, Judge.
All right,
Thank you.
the court sets Mr. Hyder then for docket call February 5th at 1:30. Who do you want next?
Judge, next we have Mr. Lassiter.
All right, court call CR 25-209, State versus Cody Ryan Lassiter. Mr. Lassiter being set for free trial. Go ahead.
Yes, Judge. Through my conversations with the state, based on the evidence that I've been provided in the state's own file, as well as extraneous information, I believe that there's some severe jurisdictional issues with this case. I believe the state is going to be asking for some time to consider those issues. So my request would be we reset it for pretrial for the state to review the jurisdictional issues with this case.
And that's correct, Your Honor. I need somebody to take a look at some of the technical information, who knows a little bit more about it than I do, who can interpret it for me and tell me what it means. So if we could get another pretrial setting, should be able to move pretty quickly after that.
All right, court sets Mr. Lassiter for pretrial February 5th, 1:30. Who would you like next?
Judge, next we have Mr. Patrick Richardson.
Court call CR 25-186, State versus Patrick Lee Richardson for docket call. Go ahead. Mr.
Yes, Judge. At this time, state and defense have been unable to come to an agreement. I have provided mitigating exculpatory evidence that I believe would be dispositive, but the state and defendant at this time disagree. So the request to be set on jury selection.
And what offer, if any, was made that's being rejected today?
Judge, as my client has asserted his innocence throughout this entirety of this process, I don't believe we ever received an offer. So I don't think one was extended.
It was a while ago though, but it was for 5 years TDC. I don't remember if there was a fine amount attached to it.
All right, the court finds that the defendant having requested a trial, is he requesting a jury trial?
Yes, Judge.
All right, court sets Mr. Richardson in on the court's trial docket. We'll begin that next week on January 12th. And he'll remain on the court's monthly docket until he reaches trial preference. Thanks, Mr. Brown.
Judge, next ready on Mr. Judson Wilson.
Judson Wayne Wilson, CR 24-227 and 228. Go ahead, Mr. Manning. I think we're set for docket call.
Yes, Judge. From pretty early on in this case, I have made the argument that this is a case of mistaken identity. And in my conversation, of course, of preparing for this docket with the state, it came to our attention that some of the materials that were part of the case file were not, in fact, part of Mr. Wilson's case file, but part of another case file. And that it appears that the discovery is either incomplete or inaccurate at this point in time. So I guess we're going to ask for another docket call so that the state can give us all the information necessary for us to make a determination on this case. But at this time, we are ready for trial and ready to proceed.
State.
Yeah, Your Honor, it looks like there could potentially be some cross-contamination with some of the information provided. Some of this was other counties providing some information that they believe that they had. So really, we need to look and see whether it is cross-contamination, whether it's is part of this case. It's mostly a determination of whether the information is relevant or not. If it very well could be dispositive, Your Honor. But at this point, we just haven't had a chance to really dig in and look at it.
All right, court's going to set this case for final docket call on February 5th, 1:30.
And Judge, at this time, that's all the resets that I have at this point in time.
Okay. All right, court will stand in recess and give you time to work with the other clients. Just notify Ms. Abraham when you're ready.
Thank you, Judge.
Your Honor,
Yes, ma'am.
we should have a 2 o'clock Spanish interpreter if Miss Bill or I don't remember which one. If they show up, would you let us know? That is
I will.
Mr. Manning's. Okay.
I will. I'll be watching. All right, court's in recess.
guaranteed, or you want to go as and then and come on, that's just but I'm sitting over here. I think you tell the truth. I have to get trouble. Maintain my temper.
Your Honor, he can hear the interpreter.
All right, very well. Good afternoon. It's Deju, is that correct? All right, Ms. Deju, if you will raise your right hand and state your name and license number as I swear you in. Ms. Deju, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the statements of counsel, and any testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Thank you. Thank you, ma'am. All right, court calls cause number CR 23-62, State of Texas versus Ivan Molina Hernandez. And Mr. Manning, I believe that Mr. Molina Hernandez he was set for a plea today, but I'm anticipating a different announcement. Is that correct?
That's correct, Judge. When I spoke to Mr. Molina Hernandez, I was able to gather that there are defenses to the violations in the report. However, due to both the language barrier as well as a gap in Mr. Molina's memory or knowledge, I will need to make an oral motion for a bilingual investigator to gather the information necessary to present to the state and to the court for why Mr. Molina would not be in violation or was not in violation of his conditions of probation.
Okay, and did you say due to his knowledge, a gap in his memory? Is that what you said?
Yes, Judge, it's my belief that my client suffered a medical incident and was hospitalized during the entirety of his time on probation prior to the motion being filed. But unfortunately, due both to the language barrier as well as the memory gaps in Mr. Molina's memory, I was unable to attain that information from my conversations with him. I used both a unlicensed translator as well, interpreter, as well as digital translation devices in attempts to come at it from several different angles, and I was unable to learn of where Mr. Molina Hernandez had been hospitalized after his injuries.
Okay, so your request is for the court to court appoint a bilingual investigator.
That is correct, Judge.
And have you identified any bilingual investigators?
Judge, unfortunately, I have not.
Okay, then if you will file I'll grant your motion, but I'll need you to, I don't have a list of people willing to serve as bilingual investigators to the
Yes,
court.
Judge.
I'll need you to do the work on that and then notify the court of what the anticipated retainer is going to be before you hire the investigator.
Yes, Judge. And what I'll do is when I locate one, I will provide that information to the court and then just include the name and contracted agreement for that amount in the order granting motion for bilingual investigator to be appointed.
Yes, sir. Okay. Mr. Molina, do you have any questions of the court or Mr. Manning before we conclude your case?
No, simplemente yo no pude asistir porque a mí me encontraron en la
Well,
calle.
okay,
Mire
well, hang
cómo
on.
quedó mi mano.
Please, Please instruct him that I don't want him to discuss any facts of the violations, but does he understand what his attorney is stating, that to resolve the case, he needs the assistance of an investigator to verify some of the facts, evidence, and claims?
Sí.
Okay. And you said, Mr. Manning, this is a motion to revoke or a motion to
A
adjudicate?
motion to adjudicate, Judge.
Okay. All right. So what we'll do is we will reset this for February 19th on the evidentiary docket.
Thank you, Judge.
All right. Thank you, Ms. Deju. I believe that's all we needed today. You as well.
Judge, also ready to reset Mr. Earl Mosley.
Mr. Mosley, come on up. This is cause number CR 25-236, State versus Earl Eugene Mosley for docket call. Go ahead, Mr. Manning.
Judge, we've reached an agreement and I conveyed that to the state. However, I was informed over the lunch break that due to some of the new notification requirements that the state is under, that they would be unable to go forward with the plea today. So we'd request, because it is a probation plea, that we set this as soon as possible for as soon as the state is able to fulfill their notification requirements, so that Mr. Mosley may begin his probation.
Mr. Harwell.
Yes, Your Honor. We can set it out as soon as the next available docket. We just have to have a 5-day headway to give notification, and we have sent out victim impact statement and everything, but with no response, we still have to reach out and make that contact, that communication, at least the attempt.
All right. So we're setting for plea, Mr. Manning.
Yes, Judge.
All right. Court sets Mr. Mosley then for plea on January 22nd at 1:30.
Now I have one. Judge, next ready on Miss Longoria.
Court calls CR 25-256, State versus Dixie J. Longoria. Show that she is set for arraignment.
Yes, Judge, I believe. If I may just have just a second.
Yes, sir.
Judge, it looks like my connection is not strong enough for me to pull up the indictment that I had pulled up earlier. If we may have the indictment pulled up, so I can go over that with her.
Yes, sir. Stand by.
Initial set. No charge against you as well as any punishment. So I introduce. So it'd be a doctor. So they charge you with a third degree felony as your name. So the Dixie J. Or so I'm also going to about the option. So just one second. Judge, Ms. Longoria's name is spelled correctly. She understands the charge against her as well as the range of punishment. Her plea is not guilty and she requests to be set on the pretrial docket. Additionally, Judge, there is one additional matter that I may need to bring back to the court's attention after we get her reset for the pretrial. So I may ask to have her recalled here in just a moment.
All right, court enters Ms. Longoria's plea of not guilty into the record. Court finds that she's waived the formal requirements of arraignment, and the court sets this matter for pretrial hearing on February 5th at 1:30.
Was it formal requirements to put it that way?
So we could be read out the dagger indictment.
Can you go ahead? Thank you, Your Honor. Okay, yeah. No, I'll try to do that. Okay.
Judge, that's all I have ready at this time. I have still have paperwork to go over with the rest of the pleas that I have today.
Yes, sir. Court will stand in recess.
We're gonna bring it back.
Probably.
All right, who are we ready with first?
Judge, I believe all the plea paperwork has been completed. If you want to start with Mr. Hagel.
All right, Mr. Hagel.
I'm sorry, Judge. If we can start with Ms. Hatton. I forgot that we need to do her first.
All right, Ms. Hatton. This is cause number CR 25-146, State versus Miranda and Hatton. Give me just one moment, Ms. Hatton. I'll pull it right
Yes, sir.
here.
Your Honor.
All right, Ms. Hatton, if you'll raise your right hand, I'm going to place you on oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
I do, Your Honor.
Thank you. You can lower your hand. Your name is Miranda Ann Hatton, is that correct?
Yes, Your Honor.
Ms. Hatton, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, Your Honor.
Do you understand everything that you've read and signed today that's part of your plea agreement?
Yes, Your Honor.
All right, Mr. Manning, do you believe Ms. Hatton to be competent to enter into a plea agreement? And if so, that she's doing it intentionally, knowingly, and voluntarily after having been fully informed of her legal rights?
Judge, I do believe she is competent today. I do believe she's entering into this plea intentionally, knowingly, and voluntarily. And I do believe she's waiving those rights intentionally, knowingly, and voluntarily as well.
Thank you, Mr. Manning. All right, Ms. Hatton, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than 1 gram, less than 4 grams. A third-degree felony in the state of Texas does carry a range of punishment of not less than 2 years or more than 10 years in prison and a possible fine not to exceed $10,000. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending that the court consider the evidence, convict you of the offense, assess your punishment at 7 years confinement in prison, with that prison sentence being suspended and you being placed on 5 years of community supervision. In addition, you would be assessed a $1,000 fine, restitution in the amount of $180, reimbursement fees of $535, and court cost of $290. And as a condition of your community supervision, you would be ordered to go to rehab. Is that your understanding of the plea agreement, Ms. Hatton?
Yes, Your Honor.
And Ms. Hatton, understanding everything that I've instructed you on regarding the range of punishment and the plea agreement, I would ask you, how do you plead to possession of a controlled substance in penalty group 1, greater than 1 gram, less than 4 grams?
Guilty, Your Honor.
You're pleading guilty to that crime because you are guilty of committing the crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir, Your Honor.
All right, the court accepts the defendant's plea of guilt. Mr. Manning, any objection to the evidence?
No objection as offered.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court will consider the evidence at this time. All right, the court, having considered the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. The court hereby convicts the defendant of possession of a controlled substance in penalty group 1. greater than 1 gram, less than 4 grams, a third-degree felony, assesses punishment at 7 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence today, places the defendant on 5 years community supervision, orders her to pay a $1,000 fine, $290 court cost, $535 in reimbursement fees, and $180 restitution. And the court orders the defendant to attend safety as a condition of her community supervision. All right, Ms. Hatton, today, I don't know how you feel about today. How do you feel about today?
I've been praying about it. I feel like this is the best move for me
Why do you feel that way?
because I think this AP is going to do me a lot of good, change my way of thinking.
Yeah, it's got to be scary to wake up with someone, a friend of yours, doing CPR on you due to
To see it.
abuse. Yeah, I mean,
Mm.
you're lucky to be here today. So
Yes, sir.
any day that you decide that it's a bad day and you don't feel so good, the alternative is you could have died that day.
Yes, sir.
So keep that in the back of your mind when you go down there and have to put in hard work to change your habits, change your mindset, and get help with your problem. Okay.
Yes, Your Honor.
All right, Ms. Hatton, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted. After that, you'll meet with the probation officers and they'll give you more information about safety.
Thank you, Your Honor.
You're welcome. Mr. Manning, go ahead and bring up your next client while I'm signing these plea papers, please.
Focus.
All right, Mr. Manning, who do you have with you?
This is Mr. Hagel.
All right, this is cause number CR 24-232, State of Texas versus Michael Tanner Hagel. And is Mr. Hagel entering a plea today?
Yes, Judge.
Give me just 1 moment. Has FC 2579, has that been transferred to my court?
Judge, I believe my discussions with the state this morning was that we were going to transfer those up. I don't know if the paperwork has been completed on that. Ms. Abraham's saying that she did not do it. So Judge, I would ask that if we can just forward those to Judge Winters for his signature.
Well, unfortunately, we can't do that in our current setup of digital pleas. Each field has to be completed for the document to be signed by me, the relevant portion. So I'm going to sign them today. I don't think Judge Winters would have an objection.
Yes, Judge.
And I think I do have concurrent jurisdiction with him, but and what kind of credit time is Mr. Hagel entitled to?
Judge, my calculations show 464 days credit total. I was given two different numbers by the state. One was 235 days credit and one was 229 days credit. And doing the math here, On paper, I believe that comes out to 464.
Any objection from the state on that?
No objection, Your Honor.
All right, Mr. Hagel, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Michael Tanner Hagel, is that correct?
Yes, sir.
And Mr. Hagel, you appeared before this court on April 8th of last year, 2025. You pled guilty to the second-degree felony offense of robbery. The court heard the evidence, found that there was enough evidence to convict you, but the court followed a plea agreement and a recommendation from the DA's office, and the court deferred a finding of guilt and placed you on community supervision for a period of 8 years. It was during that period of community supervision that the state filed a motion to adjudicate your guilt and revoke your community supervision. And in that motion, they alleged 4 violations of your community supervision. Have you had enough time to review those allegations of violations with your attorney, Mr. Jonathan Manning?
Yes, sir.
Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you understand everything that you've read and signed in your plea agreement?
Yes, sir.
Do you have any questions?
No, sir.
Mr. Manning, do you believe Mr. Hagel to be competent to enter into the plea agreement today? And if so, that he'll be doing so intentionally, knowingly, and voluntarily?
I do, Judge.
And will your client be entering a plea of true to all 4 counts as alleged?
Judge, yes, he is. The 3 new alleged offenses are part of the plea agreement, are also being 1245 and dismissed. One of those, as my client and I discussed, there may have been a potential defense, but he is recognizing his culpability in those and asking the court to dismiss those. But he's pleading true to each and every one of those counts as listed in the motion to adjudicate.
Does he waive the reading of the state's motion in those counts?
He does, Judge. We reviewed those previously.
Okay. All right, Mr. Hagel, then at this time, I would ask you, how do you plead to counts 1, 2, 3, and 4 as contained in the motion? Are those counts true or not true?
True.
And has anyone threatened, forced, or pressured you to plead true to those counts?
No, sir.
All right, the court will accept the defendant's plea of true to counts 1 through 4 as alleged in the motion. Mr. Manning, any objection to the admission of the defendant's plea of true and waiver rights?
No objection as offered, Judge.
All right, then that is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. All right, the court is going to find that the defendant has violated the terms and conditions of his community supervision. The court is going to follow the plea agreement between the defendant and the state. The court hereby adjudicates the guilt and convicts Michael Tanner Hagel of the second-degree felony offense of robbery. The court hereby revokes his community supervision, assesses his punishment at 18 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and the court dismisses under Section 1245 of the Texas Penal Code, evading arrest or detention, cause number 2025-430, failure to ID, cause number 2025-431, and felony possession of controlled substance, FC 25-79. Court also awards Mr. Hagel 464 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Hagel, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Mr. Manning, I'm going to sign these plea papers if you'll go ahead and get your next client.
Yes, Judge.
Who do you have with you?
Is this Mr. Gonzalez?
Ms. Gonzalez be pleading on cause numbers 232 and 233.
Yes, Judge. Part of the plea, the terms of the plea agreement are that she's be sentenced to 6 years TDC on each of the 3 counts. Those would run concurrently with a single fine in 231 of $3,000.
So 231, is it also a plea or is it a 1245?
No, all 3 of those will be pleas.
Just a second, I'm not finding them.
I believe there were some 1245s in 231 at the front of the paperwork. But underneath those 1245s for terroristic threat and evading, there is the plea paperwork for 231.
The plea papers for 232 and 233. See the 232, the assault on peace officer judge. See that one, 6 years.
We have been having some connectivity issues out here with both the sheriff's office and the hotspot. So I'll go back and make sure.
Double checking my inbox as well. I did a search for Gonzalez and those 2 popped up and only those 2. Can we do Ms. Craxton while we're waiting on Ms. Gonzalez? So I do have that one.
Yes, Judge.
Let's do Ms. Craxton and then we'll circle back to Ms. Gonzalez. All right, this is cause number CR 23-182, State of Texas versus Amber Elizabeth Graxon. Ms. Graxon, if you'll raise your right hand, I'm going to place you on oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Ms. Graxon, you appeared before this court on January 7th of 2025. You pled guilty to the second-degree felony offense of possession of a controlled substance greater than 4 grams. less than 200 grams. On that day, the court heard the evidence, found that there was enough evidence to convict you of the offense. The court followed a plea agreement that you reached between you and the DA's office, and the court followed the plea agreement and placed you on deferred community supervision for 4 years and assessed a $750 fine. I see that the state has filed a motion to adjudicate your guilt and revoke, and they have alleged 7 violations or allegations of violations. Have you had enough time to review that motion and those allegations against you with your attorney, Mr. Jonathan Manning?
Yes, sir.
Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you understand everything that you've read and signed?
Yes, sir.
Do you have any questions?
No.
Mr. Manning, do you believe Ms. Braxton to be competent to enter into this plea agreement? And if so, that she's doing it intentionally, knowingly, and voluntarily after having been fully informed of her legal rights?
Judge, I do believe that she is competent, and that she is entering into this plea intentionally, knowingly, and voluntarily.
Does she intend to plead true to all 7 counts?
That's correct, Judge.
Does she waive the formal reading of the state's motion?
She does.
All right, and Ms. Braxton, I see that upon you pleading true, the state's offered you a plea agreement. That plea agreement is that your guilt would be adjudicated today, that your community supervision would be revoked, that you would be sentenced to 5 years in prison, that you'd be ordered to pay the financial obligations that you had imposed previously, fines, court costs, restitution, and reimbursement fees, and you would receive credit time towards your sentence for the time that you've already spent in jail. Mr. Manning, how much time is that?
323 days.
So, Ms. Craxton, that's what you would receive towards your sentence. Ms. Craxton, is that your understanding of the plea agreement and what you're asking the court to approve?
Yes, sir.
All right, very well. Ms. Craxton, then I would ask you, how do you plead to the counts alleged in the state's motion to adjudicate and revoke? Are those counts true or not true?
True.
And has anyone threatened, forced, or pressured you to plead true to any of those counts?
No, sir.
All right, then the court does accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection, states one.
All right, that document is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, then, of course, based on the evidence and the defendant's plea of true to the allegations contained in the state's motion, the court finds that Amber Elizabeth Craxton has violated the terms and conditions of her community supervision. The court finds the counts to be true. On that finding, the court hereby adjudicates the defendant of her guilt for possession of a controlled substance greater than 4 grams, less than 200 grams. The court revokes her community supervision, assesses punishment at 5 years confinement in prison, and orders her to pay the balance of her financial obligations, and awards her 323 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Craxton, once you are released from prison, if you've not paid off your fines, court costs, and fees, then you're to report to the Van Zandt County Courthouse to make a payment arrangement. Otherwise, you could be rearrested for failure to pay your fines. You understand?
Yes, sir.
All right, please step over to be fingerprinted.
Thank you.
Circle back. Okay. All right. Now I have 231 for Ms. Gonzalez. Let's go ahead and bring her back up.
Oh.
All right, we are back on record in cause numbers CR 25, 231, 232, 233, State of Texas versus Danielle Nicole Gonzalez. Ms. Gonzalez, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, Lori. All right, give me just one moment. Let me look through your paperwork. Mr. Manning, how much credit time on each case?
160 days.
You said, say that again.
160 days.
And is that on each case?
That's correct, Judge.
Thank you. All right, Ms. Gonzalez, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Just bipolar, but that's it.
Okay. Are you currently on medication or treatment for bipolar?
Yes, sir.
Ms. Gonzalez, do you feel like you have a rational understanding of what's going on today and you're able to fully understand everything that's occurring in this court proceeding?
Yes, sir.
You are represented by your attorney today, Jonathan Manning. Are you pleased with him as your attorney?
Yes, sir. I am.
Do you understand everything that you've read and signed in your plea agreement?
Yes, sir.
Do you have any questions about anything?
No, sir.
Mr. Manning, do you believe Ms. Gonzalez to be competent? And if so, that she's entering into these agreements intentionally, knowingly, voluntarily, after having been fully informed of her legal rights?
Judge, she is competent, and I do believe she's entering into this plea intentionally, knowingly, and voluntarily.
All right, Ms. Gonzalez, I see in cause number CR 25-231, you are charged with a first-degree felony offense of assault of a peace officer or a judge. And that does carry a range of punishment of not less than 5 years in prison or more than 99 years or life confinement in prison, and a possible fine not to exceed $10,000. In that case, there appears to be the plea agreement of, upon you pleading guilty, the DA's office is recommending that the court consider the evidence, convict you of the offense, assess your prison sentence at 6 years, order you to pay a $3,000 fine plus $290 court costs, $20 in reimbursement fees. They're asking that the sentence in this case run concurrent with their recommendations in the two other cases of 232 and 233. As part of the agreement in this case, the DA's office is agreeing to reject an unfiled or uncharged rather criminal offense of resisting arrest, search, or transport, terroristic threat against a peace officer, and also a terroristic threat against two unfiled charges of terroristic threat against peace officer. And you would receive 160 days credit towards your sentence for the time that you've already been in jail in this cause. Is that your understanding? Also that there is a enhancement paragraph in your case, and that you would be pleading true to that. Is that your understanding of the plea agreement in that case?
Yes, sir.
Okay. And I know it's a lot, but we're going to go through each one of these just so we can make sure we're doing it correctly. In cause number CR 25-232, you are charged by indictment with assault of a peace officer or a judge in that case as well. And that is also a first degree felony, also has an enhancement paragraph, the range of punishment being a minimum 5 years in prison to a maximum 99 years or life in prison with a possible $10,000 fine. The plea agreement in that case is that upon you pleading guilty and true to the enhancement paragraph, that the state's asking for the court to sentence you to 6 years confinement in prison with that sentence to run concurrent, and you would also receive 160 days credit towards your sentence in that case. Is that your understanding of the plea in that case as well?
Yes, sir.
Any questions about anything on that case?
No, sir.
Okay. And then lastly, CR 25-33, assault of a public servant, a second degree felony that has an enhancement paragraph. The range of punishment being not less than 2 years in prison or more than 20 years in prison, and a possible fine not to exceed $10,000. The plea agreement being the same. Upon you pleading guilty, The state's recommending that the court assess your punishment at 6 years confinement in prison, with that prison sentence to run concurrent with the other two, and for you to plead true to the enhancement paragraph, and that you would receive 160 days credit toward your sentence in that case. And is that also your understanding of the plea agreement in that case?
Yes, sir.
Okay. All right. So Ms. Gonzalez, I'm going to ask you at this time, how do you plead to assault of a peace officer or judge, a first-degree felony in cause numbers CR 25231 and CR 25232? You plead guilty. And has anyone threatened, forced, or pressured you to plead guilty to those crimes?
No, sir.
Okay. And with regard to CR 25233, how do you plead to assault of a public servant, a second-degree felony?
Guilty as well.
And Ms. Gonzalez, in each one of your cases, the DA's office has alleged that you have a prior conviction that's embodied within a enhancement paragraph. Is the allegation of your prior enhancement or your prior conviction, is that allegation true or not true?
True.
And has anyone threatened, forced, or pressured you to plead true to the enhancement paragraphs in each one of your cases?
No, sir.
Very well. All right. Then the court hereby finds that the defendant has pled true to the enhancement paragraph. Mr. Manning, any objection to the admission of the state's evidence in each case?
No objection is offered.
All right, then the stipulation of evidence is admitted in each case respectively, and the court takes judicial notice of the defendant's pleas of guilt and the defendant's pleas of true. Anything further from the state?
Your Honor, only that law enforcement is supportive of the plea, and also just for the court's reading time, the stipulation is the same in all three cases. It's just copied and pasted in all three.
All right, thank you, Mr. Harwell. Mr. Manning, anything further on behalf of Ms. Gonzalez?
Better be rest and close.
All right, court will consider the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of each offense. The court hereby follows the plea agreement in each case. The court hereby convicts the defendant in cause number CR 25233 of assault of a public servant, a second-degree felony. Court finds the prior enhancement paragraph to be true. Court assesses punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders that the sentence run concurrent with cause number CR 25232 and CR 25231. Court orders the defendant to pay $290 court costs and $20 reimbursement fees, and awards her 160 days credit towards her sentence for the time spent in jail on that cause. In cause number CR 25231, on the charge of assault of a peace officer, the court finds that there's enough evidence to convict the defendant, and the court hereby follows the plea agreement, assesses punishment at 6 years confinement in the Texas Department of Criminal Justice, orders her to pay a $2,000 fine, orders the sentence to run concurrent with the other sentences. Court hereby dismisses as part of the plea agreement unfiled DA cause numbers DA 2025841, resisting arrest, DA 2025840, terroristic threat against a peace officer, and DA 2025839, terroristic threat against a peace officer. The court further finds the enhancement paragraph to be true in this case. The court, having assessed sentence and court costs, also awards 160 days credit towards her sentence for the time that she has spent in jail on that cause. And then lastly, CR 25232, court, having considered the evidence, finds enough evidence to convict the defendant of the offense. The court does convict her of the offense, assesses her punishment pursuant to the plea agreement at 6 years confinement in the Texas Department of Criminal Justice, orders the sentence to run concurrent. Court finds the prior enhancement paragraph to be true, and the court orders her to pay court costs of $290 and reimbursement fees of $20, and awards her 160 days credit towards her sentence for the time that she has spent in jail on that cause. I do see that I'm unable to insert the credit time on the judgment for cause number CR 25232. There's no field for me to enter, so we'll need to make that adjustment once we conclude in this case. So there may need to be a nug pro tunc. So just note that, Mr. Hartwell, because there's no way for me to insert that at this time. All right, Ms. Gonzalez, the court, having heard the evidence, has convicted you of the offense and followed the plea agreements. You're hereby remanded to the custody of the sheriff, so he carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted.
Thank you.
You're welcome. Go ahead and sign some. Yes, Mr. Manning. If you got another client, you can bring them up or you can wait, either one.
Judge, I believe we're ready on Mr. George.
Run. Yeah. Yeah. Oh, he's not even in there. Sure. Yeah.
I'll get you back later. All right, yeah.
All right, this is cause number CR 25-268, State of Texas versus Brock Albert George, set for arraignment today on a second-degree felony offense of burglary of a habitation. You ready to proceed, Mr. Manning?
Judge, before we proceed, Mr. Brock was as recently as Tuesday in the Terrell State Hospital on, I believe it was approximately 7 mental health cases filed out of the county court. By the time that it came to my knowledge that he was there in Terrell State and that those commitment orders had come from the county court, he was already being transported back here to Van Zandt County for our hearing today. I believe that Mr. George would continue to benefit from continued treatment in Terrell State. And I've talked to both Mrs. George, his mother, as well as some of the staff at Terrell State Hospital. And I believe that at this time, if the court would accept his recent evaluation and commitment to Terrell State, as a suggestion of incompetence, and in order that he be returned back, I believe he could be restored to competence there at Terrell State with some additional treatment.
Has he been evaluated for competency, or was he just evaluated for harm to self or others?
Judge, he has not been evaluated for competency at my request. When I first met with Mr. George, it was right after the appointment, and then it showed that he was no longer in our system or custody, and so I assumed that he had bonded out or been released. It wasn't until, like I said, this week that I became aware that he had not been released from Van Zandt County custody, but had in fact been in Terrell State on those mental health orders from the county court. Like I said, I believe there were 7 cases that were filed.
So he remains in our custody, and then he was brought back today for court. Is that correct?
Judge, I'm not sure if they discharged him or if they brought him back for court. That's what I'm still trying to get to the bottom of, because it wasn't a part of our case. I didn't receive notification of his commitment there, or the length and situation of his treatment in Terrell State. I've been trying to get with the county court to ascertain that information, but was unable to do so before court began this morning.
All right, then what I would suggest we do is we reset the arraignment today to January 22nd. And Ms. Tabraham, she'll be able to assist. We should be able to get some of that paperwork from the Van Zandt County Justice Center as well, if he was committed from our custody. And so let's do that, and then we'll reevaluate on the 22nd. If he's been discharged, then if we need competency, then we can go ahead and order a competency evaluation. If he's back in Terrell State, then what we may be able to do is just reset the case until he continues to get his mental health meds, and maybe gets him to a state to where we can reevaluate later whether or not he needs a different evaluation than what he's received.
Yes, Judge.
All right, so we'll reset to January 22nd, 1:30. And then Ms. Tabraham, if you could just assist and get any kind of discharge paperwork that has been received by the jail from Terrell State Hospital.
And Your Honor, if I may, if Mr. George does get discharged in the interim and makes bond, state would just request that pretrial release conditions include a no contact and order with the alleged victim, as well as not coming within 500 feet of the alleged victim or his property.
All right, that will be granted. I'm not sure if I've already executed any pretrial release conditions. I don't know that we have anything specific. We have standing pretrial release conditions. So Ms. Tabraham will need to make a note to amend the standing order to include specific information on the victim, alleged victim, if we do not already have that in there.
Thank you, Your Honor.
All right, thank you, Mr. George.
Just say that.
All right, Ms. Tabraham, our discussion on Mr. Powell. I don't think I've called Mr. Powell up today at all. I don't have any notes on him.
And Your Honor, he's not the one that you were thinking about earlier that rejected the offer. So I don't think we brought Mr. Powell up at all.
Judge, during one of our breaks, there was a discussion that was had between myself and Mr. Powell. It escalated, and Mr. Powell, at that point in time, let me know in no uncertain terms that he no longer wished me to be his attorney, that he wished to have a jury trial, and that he needed a new lawyer. And at that point, he was because of his disruptive behavior, needed to be removed from the courtroom. I told him I would convey his request for a new attorney, and his request stemmed from what he believed was an unfair offer made by the state regarding the resolution of his case, and his perception that I would somehow be able to get something different from that.
Thank you. I appreciate the input. Can we bring Mr. Powell up, or is he going to be combative?
I'm not sure, Judge.
Sergeant Martinez, do you have an opinion on
Yes,
that?
sir. Whatever you want, Judge.
Do you think he's going to be combative?
Sergeant Martinez wasn't here
Do
when
you?
that incident took place.
The other jailer is claiming right now that it's, either way, could go either way.
All right, so we need to get him on record because I need to arraign him, and we need to take up these issues. So I can't
We'll
let
get
him.
him.
Yeah, I can't let him dictate what's going to happen in court. If he needs to be restrained, then you have my authority to restrain him, gag him
Yes.
if you need to.
Yes, sir.
I'm gonna go and get the paperwork on Mr. George.
Okay, great. Thank you.
Your Honor, we're ready.
All right, we are on record, cause number CR 25-272, CR 25-282, State of Texas versus Michael Ray Powell Jr. Mr. Powell, you've been indicted on 2 charges, one being unlawful possession of firearm by a felon, a 3rd-degree felony, and also evading arrest or detention with a vehicle, also a 3rd-degree felony. 3rd-degree felonies carry ranges of punishment of not less than 2 years or more than 10 years in prison, and possible fines not to exceed $10,000. You've requested a court-appointed attorney. The court has appointed the Honorable Jonathan Manning to represent you. Mr. Manning, are you ready for arraignment?
Yes, Judge. And cause number 282, CR 25-282, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment, and his plea is not guilty. He requests to be set on pretrial for both cases so that we can begin the process of getting discovery and negotiations.
Is that in both cases?
Yes, Judge.
Okay. All right, then the court enters the defendant's plea of not guilty into the record on both charges. Court finds that he's waived the formal requirements of arraignment, and the court sets this matter for pretrial hearing on February 5th at 1:30. Anything further, Mr. Manning?
Judge, that concludes my business on this case. May be excused.
Yes, sir.
Your Honor.
Yes, ma'am.
Okay, back on Mr. George, Lisa said that he was discharged from Terrell State Hospital. She received paperwork and she will forward that to me.
Okay, so he was discharged. So, do you know if
According to
he's
Lisa, the nurse.
right? Do you know if he's still receiving his medications, whatever he was prescribed at Terrell State?
And she's just now, I mean, they've just now brought the paperwork in here. Let's see.
Well, let's just do this. We don't have to do it now, but
Okay,
we need to follow up to make sure to see if he's getting mental health meds. And if he is, let's just give him whatever he's prescribed.
Okay.
And we will reevaluate on the 22nd. If he's not on medication and he needs to be, then we may need to get him evaluated by Dr. Ingram sooner rather than later, or get Andrew Center over here to see if one of their doctors can visit him and see if we can get him on meds. And if he won't take meds, then go the forced meds route.
okay, Your Honor. Now Lieutenant is in here and she said he is taking the medication that Terrell State Hospital has ordered with no problems.
Good.
So with
All right,
no
excellent.
problems.
Well, good. Well, we'll wait till the 22nd, let the
Okay.
meds get on course, and we'll reevaluate it on the 22nd. Thank you, Mr. Manning.
Judge, may I also, off the record, make a quick announcement for Ms. Cormier? During my lunch break, I spent a good portion of that talking to the Andrews Center, specifically Ms. Trussell, their IDD intervention specialist. In speaking to her, I made her aware of Ms. Cormier's situation and impending release from Van Zandt County Jail. I also let her know of some of the issues that have presented themselves in Ms. Cormier's situation and forward her the information that I had regarding Ms. Cormier's charge and incarceration. She's going to do her best to get Ms. Cormier set up for an appointment with Andrews Center and provide mental health services as well as transitional services for Ms. Cormier when she gets out. As of about 15, 20 minutes ago, Ms. Cormier was still in custody here at Van Zandt County. And so I'm going to go speak with the staff and see what the delay is, and then see if Mr. Trussell will be able to speak to Ms. Cormier before she's released.
Excellent. All right, Mr. Manning, I appreciate that. That's above and beyond work, and I do appreciate it.
No problem.
Thanks, sir. All right, I believe that does conclude all of our criminal cases at the Justice Center for this afternoon. Court is adjourned. Thank you
Thank
everyone
you.
for their work.
Thanks, sir.